Right, welcome everyone. Thank you for joining me. My name is Lior Samfiru. Yes, I'm the employment lawyer. And why am I here? Well, I'm here to talk to you about employment law. Obviously, that's what I do every Wednesday at this time. I come here live and I try to get your problems resolved. So, again, if you're joining us for the first time, welcome. My name is Lior Samfiru. Again, I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We practice across Ontario, British Columbia, and Alberta. And if you're having an employment issue, boy, are you in the right place right now. You can ask your question about your legal rights. You can make sure that I get to read it and answer it. If you're dealing with a bad boss, a bad employment situation, a stressful environment at work, maybe your job has changed, maybe your hours are not the same that they were. Maybe you lost your job and you want to know what your rights are and how legal this whole thing is. I think you get the idea. All those issues and much more, you can ask me right now. You can tell me what the issue is, and I'll tell you what the answer is, what you can do, what the law says, and what rights you have. Now, that word rights is very important because we have rights. All employees have actually very significant rights across Canada. When it comes to employment law, and you've heard me say this before, we have some of the best employment laws in the world right here in Canada. Unfortunately, too many people walking around working not knowing what those rights are. Well, by joining me here today or by watching me on TV or listening to me on radio, you can learn everything you need to know about your workplace rights so that you're protected. So no one takes advantage of you. So you don't have to feel that you've missed out on the legal rights that you have. So ask the question. I'm live here for you, with you to get those questions answered right now. I got lots of time. I want to see lots of questions. Now, beyond the 30 minutes of this live stream, if you want to connect with me off air, you want to have a private discussion, a private email exchange, so easy to do. You just go to employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. When you go there, phone number is there, email address is there. If you'd rather just fill out a form and have us call you, you can do that as well. It's all right there for you, employmentlawyer.ca. And of course, you can read much more about employment law while you're there if you want to. But right now, I am live. You're live. You're watching. Well, don't just watch. Let's make sure you get those questions answered. So right now, let's make sure I'm going to start answering questions right now. As you're listening to me answer other people's questions, ask yours. Last few weeks had lots of questions. I want to have even more questions to answer today. So please, if you're watching, let's make it interesting. And by the way, by asking me a question and having me help you, you're going to be helping others who are probably in the same situation or have wondered the same thing. So do it for yourself, do it for them, and let's make sure those questions are answered. So again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm going to go right now and start answering questions. So ask them. I'm going to start. Let's see. First question from Sherry. Could engaging in a protected activity, such as requesting accommodation, help prevent my termination? I'm on a 60-day performance improvement plan and worry it's a step towards letting me go. I've heard that pulling a move like this could stretch things out to 6 months or more, or even improve my chances of getting a better severance at the end. Is that true? No, it's not true. It's not going to avoid the termination, and it's certainly not going to have an impact on your severance. The law decides what your severance is, and whether or not you've asked for accommodation or not is not going to change that. But here's the thing. If you think your job performance is impacted by your health, in other words, you feel that you weren't doing the job to the best of your ability because you're dealing with some health issues, tell your employer that. Better yet, get a doctor's note. Doctor's note can say, for health reasons, her job performance has been impacted. She's working on making it better. If you do that, the company cannot let you go for performance reasons. Okay, because that would be potentially a human rights violation. If you have health issues, serious health issues that impact your performance, and they let you go because of bad performance, no, that's illegal. So tell your employer that. If you don't tell them that, then they don't know, and it's not going to impact your termination. Beyond that, let me say this. If you if your employer puts you on a performance improvement plan and you don't agree with it, you don't think it's fair, you don't think it's accurate, I want you to say so. Say so in writing. Send an email to your employer saying, you put me on a performance improvement plan. Here's why I don't think that's correct, or here's what you say that it's not true, or here's some other information you need to have. Put that in there. By doing that, you're going to make it harder for the company to let you go. If you don't say anything, it's exactly the same as if you've accepted it, and that could make it easier for the company to let you go. Either way, if the company does let you go, bad performance, good performance, doesn't matter. If they let you go, you call me right away. Chances are you're still going to be owed your full severance. And of course, to connect with me, Sherry, easy to do. You just go to employmentlawyer.ca. All right, that was a great question. Our first question today. A bunch of questions are coming in. I'm going to continue answering them right now. You have so much time, so ask your question. Again, I'm Lior Samfiru, the employment lawyer. Let's get some more questions answered. Eric has our next question. Is an employer allowed to schedule you on days that you are supposed to be off for religious practices? Well, if you've told your employer that you need to be off for religious reasons, and if they need proof, they've provided them proof. What I mean by proof is they may say, well, we need a letter from your rabbi, your minister, your priest to confirm that you're doing that. That's legitimate. If you've provided that information and they say, too bad, we're still going to schedule you, they cannot do that. That's religious discrimination. That's, again, a human rights violation. But if you simply tell your employer, hey, employer, I want to be off on Saturday for religious reasons, in itself, that may not be good enough. What you should do is say, employer, I need to be off Saturday for religious reasons. What do you need from me in order to make that happen? And that's how you would approach it. But if you've provided the right information, they cannot schedule you. Again, that's a human rights violation. Hopefully that makes sense. Continuing to answer questions. So happy questions are coming in. Let's make sure you get yours answered. Chris has our next question. Chris is joining us on Facebook. When you have multiple people going to HR regarding a bullying supervisor and the management refuses to address these issues, what can we do? So first of all, I want that all to be in writing, because I don't want HR to say, oh, no, you never told us, we didn't know. So the problem with doing it verbally is they can deny it, and then it becomes a he said, she said. So the first thing you do is you put it in writing. Email works great. Say, hey, HR, we need you to deal with this person here that's bullying. Here's what he did or she did, and here's all the relevant information. At that point, your employer is legally required to take it seriously, to investigate, and to rectify the problem. If they don't, if you did what I told you and they still say, we don't care, we're not going to do anything, number one, that could be a constructive dismissal. That could be a violation of several statutes. It's illegal. So the law is going to jump in and provide remedies. You could potentially leave with severance. I can force the company to do something. There's various options that you have. But the key, of course, is to put it in writing. If you've done that, nothing happens, you call me and we'll talk about those options. You may say, you know what, I don't want to work at a place like this anymore. I just want to leave with my full severance. That could be as much as 2 years' pay. Call me. Or, by the way, what do you think will happen if they get a letter from me saying, you better deal with this? See how quickly they deal with that boss that's harassing or bullying. So there's various options, Chris. But again, the key is to put it in writing so your employer can't deny that you told them about it. Okay, and for Chris, for anyone else, if you want to reach out to me, if and when you want to connect with me, so easy to do. First of all, I'm Lior Samfiru, the employment lawyer. And again, to connect with me, very easy to do. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. That's the place you go to. Phone numbers there, email addresses there, forms are there. It's all there for you, employmentlawyer.ca. Right now, I am still live, as are you. Questions are coming in. I promise you, if you ask your question right now, you will get it answered before I'm done today. So ask it right now. Don't wait till the last minute, because then I may not be able to get to it. Right now, I can guarantee you'll get an answer. So ask it. All right. Let's see. Stephen has our next question. I did not sign an employment agreement when I started 5 years ago. My employer is now having everyone sign one. Is there a problem with this? Huge problem, Stephen. Huge problem. And I'm so happy you asked. It's always a bad thing, a very bad thing, when you already have a job and your employer all of a sudden wants you to sign a new employment agreement. The best thing for an employee is not to have a written employment agreement. The only thing an employment agreement will do, the only things it will do is take away rights you would otherwise have. I can almost guarantee you that one of the things that employment agreement does is it limits your future severance. So that could be the difference between getting 2 years severance, or if you sign the agreement, getting 8 weeks severance. That could cost you tens of thousands of dollars, even hundreds of thousands of dollars. And that's just one example of probably 10 bad things that it could do. So first of all, I'm happy to look at it to tell you what it actually does. But generally speaking, bad idea to sign it, and your employer can't penalize you for refusing. Okay, you can say thanks, but no thanks, I'm good. So don't sign it. Certainly don't sign it without me seeing it first. You don't want to sign it and then realize you gave up on an entire host of rights that you would otherwise have. Very bad idea, Stephen. Again, to connect with me, if you want me to see that agreement, again, employmentlawyer.ca. All right. Great question, Stephen. I'm glad you asked it. Okay, let's continue. Maher has our next question. I was terminated after taking a medical leave. They did not bring me back and terminated me with cause by making up issues about my performance. What are my options? So, first of all, the company has to prove that you were so bad that you can be terminated for cause. They have to prove it. You don't have to disprove it. And obviously, if it's all made up, they won't be able to prove it, which means this is a wrongful dismissal. It seems to me that what actually happened here is they were trying to come up with an excuse not to bring you back from a medical leave. That's illegal. Again, human rights violation. They have to try and make all efforts to bring you back. If they say, we don't want to, we'll just come up with an excuse, wrongful dismissal, but also potentially human rights violation, illegal. So yes, at a minimum, you're going to be owed your full severance. So Maher, you have to contact me. I forbid you not to contact me. How's that? Okay, you have to contact me as soon as possible. You can do that through employmentlawyer.ca because there's severance here, there's human rights damages here, potentially reinstatement if you want your job back. So no, but this company did obviously very, very illegal. You have rights, laws protect you, and happy to chat with you and get going on this, employmentlawyer.ca. Excuse me. All right. Again, if you've just joined us right now, wondering what this is all about, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm answering questions about employment law, about workplace rights. People are asking, I'm answering. You can do the same thing. Ask those questions, get answers, know what your rights are in the workplace. All right. CNN has our next question. Can I refuse to work overtime? Can my employer make me work overtime to meet a deadline? And can my employer make me work more than 8 hours a week of overtime to meet a deadline? So those are really the same questions. Can you be told to work overtime? Can you refuse it? Generally speaking, yes, you can. You can refuse to work overtime. You can refuse to work more than your regular hours, even if your employer is paying you. The only exception to that is a situation where you signed an employment agreement where you agreed in the employment agreement to work extra hours if your employer asks you to. So if you sign an employment agreement that says my regular hours are Monday to Friday, 9 to 5, but I agree to work extra hours if I'm asked, then you have to do it. And if you don't, that could be a problem. But if you didn't sign something like this, you can say no. And your employer can't do anything to you. That said, keep in mind, your employer can still let you go for refusing. The reason for that is your employer can let you go for any reason as long as they pay you severance. So yes, your employer could let you go because of it, but they'd have to pay you severance. It would just be a simple without cause termination. But they can't discipline you. They can't avoid paying you severance. They can't refuse to schedule you. None of those things. So hopefully that makes sense, CNN. If you want to, happy to discuss. You can also say to your employer, by the way, I'm only going to work these amount of overtime hours and nothing else. That's okay as well. So hopefully, but take a look at your employment agreement and see if it says something where you've agreed essentially to work overtime if they demand of you. All right, thank you for that question. Great question. Happy to have answered it. Feel free to ask a follow-up or any other questions. I'm going to continue answering right now. Lots of questions coming in. I knew it was going to be lots of questions today. I'm happy about that. Okay. Next one is union voices for independence. If a doctor refuses to write a medical note to give to your employer because they said we don't want to get caught up in legal matters, is that enough to show you attempted to obtain a note from a doctor? No. By the way, employers, I've never seen in all my years a doctor refusing to provide a doctor's note. In fact, probably half of what doctors do is provide doctor's notes with people that can't work. So it's not going to happen. If it is, you need a different doctor or go to a walk-in clinic. But no, it's not enough to show that you've made efforts. You actually have to provide a doctor's note. So I've never seen that be an issue, honestly, thousands of matters. So I can't imagine that should happen. Okay, let's see. Chris was asking a question about bullying and harassment. I'm not sure what you're saying, Chris. It brought it in writing, denied looking at it. Doesn't matter. All that matters is that you've sent that email. So if you sent an email to your boss, your HR, saying that I'm being bullied and harassed, doesn't matter to me if they say, oh, I never read it, I didn't take the time, I never looked at it. Doesn't matter. If you put it in writing, that's it. So if you did that and they haven't responded, now we go to phase 2, which is you call me. An entire host of rights that you have. Again, you can connect with me through employmentlawyer.ca. Okay, Kathy McInnes has a question. She's joining us from Facebook. So thank you, Kathy. Can you talk about frustration of contract? Does this happen often? How can a person protect themselves from an employer claiming this? So here's what frustration of contract is. Well, there's several frustrations. That the most common, which I'm sure is what you're asking for, is in the medical context where you can't work for medical reasons. So in a situation where you've been off for a very long time and your doctor is really saying that you're probably not going to be able to come back to work again, your employer can say, well, we're not letting you go, but the employment agreement has become frustrated. Not your fault, not our fault, but because of that, we can let you go with no severance or just minimal severance because this frustration that's happened here. What happens is there's nothing that you can do if your doctor is saying you can't work again, and if you've been away for a while. The only way around it is your doctor can say she can't work now, but hopefully at some point in the future she can. So for the doctor to leave the door open a bit. If the doctor leaves it open, he doesn't say you're going to be able to, but he leaves the door open to the possibility of you being able to go back to work, then your employer can't say frustration of contract. So that's what it is. Although for an employee, I'm not sure why would you be concerned if your employer is saying frustration of contract. If you're not going to be going back to work again anyway, what does it matter? You may actually get some severance right now. So it may not be a bad thing. In fact, in some situations, it's the employee that says frustration of contract because they want to get paid. The employer says, no, we think you can come back. And the employee says, no, I am claiming frustration of contract. So think about that in that situation and think whether you're really concerned about frustration of contract. So thanks, Kathy. Follow-up questions, please ask right now. Again, for those that have joined us or are joining us right now, who am I? Well, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And what I've been doing for the last 18, 20 minutes or so is answering questions, your questions about employment law, about workplace rights, about your rights. I'm going to continue doing that right now. You still have time to ask your question. So you can listen, you can watch, but you can ask questions even better. All right, let's see. CS has our next question. Is there a time limit to how much an employer is allowed to compress work time? Are 14-day on work cycles legal? No, it's absolutely fine as long as your employer pays you at least minimum wage, pays you for overtime if you work overtime, and gives you the amount of hours free from work. Depending on your province, there's different amount of hours free from work you have to have in a week. But as long as your employer does that, they can decide what the work week is going to look like. But what they can't do is change your work week. So I'm going to give you an example. Let's say you used to work Monday to Friday, 9 to 5 as an example. Now your employer wants to do something very different. where you work 12 hours a day and then other days you work 6 hours a day. No, that they can't do. That's a change. That's a significant change to the terms of your employment. That means you could potentially consider that to be a constructive dismissal. So if your employer makes significant changes, yeah, you don't have to accept it. You can say constructive dismissal. If you ever want to say, no, this is a constructive dismissal, I'm not accepting it, I want out with my severance, before you do anything, you call me, okay? To connect with me, very easy to do, employmentlawyer.ca. All right. Holy cow, more questions coming in. Love it. Makes me very happy. Next question from DF, who's joining us on YouTube. I was verbally offered a salary increase by my boss for doubling my responsibilities, but was told it would take time to work out the details. Okay, but after months of taking this on, I was told my salary wasn't coming. I filed a complaint, but after it was verbal, so I'm out of luck. The problem is if your employer denies that they agree to give you a pay raise, then unfortunately you're out of luck because you can't prove it. If they say, we acknowledge that we promised, we just changed our mind, you actually may be able to force them, or you can consider that maybe a constructive dismissal. So you have rights. So that's why it's so important to get it in writing. If your employer, you have a meeting with your employer and your employer says, yeah, we're going to give you a pay raise, great. You go back to your office, you send them an email confirming, hey, boss, confirming that we talked today that you're going to give me a pay raise in January. Great. That's it. The one line. That's all you need. So if your boss is denying that there was ever an agreement, no, we never said that. Unfortunately, that's a bad situation because you, as the employee, have to prove that you had an agreement, and you can't really prove it if they're denying it and you don't have anything in writing. So hopefully that makes sense. And DF, if you have any follow-up, I'm still here. Let's see. Ash B has our next question. What rights do you have if an employer misled and lied about a position they offered you? Duties, pay, workplace are all completely different than what was discussed. Left a good job for lies. So the question is, how do you prove what was promised to you? Is there an employment agreement that says so? Is there emails where they say, here's what we're going to offer you? So if you can prove that they made a promise, if you can prove it, because they're not going to admit it, they're going to deny it, right? If you can prove it, then what you may have there is a negligent misrepresentation. So if you left a good job for promises that turn out to be false, they may owe you damages. That could also be a constructive dismissal, meaning you're owed severance. So there's various things. But the key, of course, is can you prove it? Can you show me something where I can say, here's what they've promised me? That never happened. If it's all verbal, unfortunately, that's not going to be good. That's why, guys, this has been a recurring theme on this session here. Always get it in writing. And you don't need the company to get it in writing or to put it in writing. You can put it in writing. So if I were you, Ash, if I had a meeting with my future employer and they say, here's what we're going to do, here's what the job is going to be, etc., I would go back and send them an email confirming what they've said and what we've agreed. That's it. Just a simple email. And by doing that, you're protecting yourself. So if you have something in writing, I want you to call me. All right. I want you to connect with me so we can talk about how do we enforce that or get you compensation or get you out of there, various things that you have. So to connect with me, easy to do, employmentlawyer.ca. Ash, so happy to connect with you and chat about it. JX2, does your firm do vehicle insurance claims in Saskatoon? A friend recently was involved in a collision. Unfortunately not, no. We don't. The Law Society there offers a referral service, so your friend may want to connect with the Law Society in Saskatchewan. We do not practice there. Guys, you've heard me mention severance a few times today, and talking about severance and being owed severance. I want to remind you, if you want to find out at any time how much severance you are owed, it is incredibly easy to do. You just grab your smartphone, tablet, desktop, whatever you want, anything with internet on it, and you go to pocketemploymentlawyer.ca. That address is on the screen right now, pocketemploymentlawyer.ca. We have several tools for you there, but the first tool you'll see is something we call the severance calculator. Ta-da, easy, right? Severance calculator. It does what I said, calculates how much severance you are owed. And it does that in seconds, and it does that anonymously, and it does that without you telling me what the company you work for is, or what your name is, or even what your email address is. You don't have to do anything other than pick some answers from a drop-down menu. So you go to pocketemploymentlawyer.ca, you click on the severance calculator, and in a few seconds, you'll find out how much severance you're owed. And you may think, well, I know how much severance. I don't need to use the calculator. I know I get a week per year or 2 weeks per year. Wrong. False. It's not that. It's very different, and it's much more. Go to pocketemploymentlawyer.ca. Check it out for yourself, whether you've just lost your job and you're staring at that severance letter right now, or you've always wondered what you'd be owed. Maybe you're curious or worried about losing your job. pocketemploymentlawyer.ca. And if you want to, only if you want to, you can contact me directly from the severance calculator so I can help you actually get what you're owed. All right. Let's see if we can get a couple more questions in from Star. My mother was laid off in November due to a work shortage. She has been waiting to be called back to work and has since learned that her employer has hired new staff and filled her position. She worked there for over 20 years. She has been laid off for periods of time in the past. Is she entitled to severance since it seems they won't be calling her back? Now, if she hadn't been laid off in the past temporarily, she wouldn't have had to accept this layoff at all. But because she accepted the past ones, then they potentially can continue, or sorry, they can lay her off now. And as long as they're continuing her benefits, this layoff can last as long as 34 weeks, as long as she's getting her benefits continued. So let's see, in November. So we're still within that time. What she can do is contact the company and says, are you going to call me back? If they say no, she's owed severance now. If she says we don't know, or yes, she has to wait. So she has to wait, continue waiting at this point, unfortunately. This would be very different if this was her first temporary layoff. If this was her first temporary layoff, she could have said, no, I'm not okay with this. You don't have a right to lay me off. Forget waiting. I'm just going to get my full severance right now. You don't have a say, employer. But because they've done it before and she accepted it, now she's given them the right to do it again this time. But after 34 weeks, it becomes an automatic termination. And again, I don't know what province she's in. It could be less than that, depending on the province. 34 would be in Ontario. So you may want to reach out to me or have her reach out to me to know for sure. All right, last question from PG today. My employer did not give me a 3-month evaluation until I asked for it several times. I had an evaluation meeting on my 4th week of employment with an awful results, and they wanted me to stay for another 2 weeks to see if they want to keep me. I did not agree with the evaluation results and commented that the evaluation shows 80% negative. My only question was, why would they keep me for 4 months if most of my actions were wrong? So I don't know why they would keep you for 4 months. I can't answer that. The best thing you could do is, if you don't agree with the evaluation, say so in writing, but be very specific. You say, I did these 3 things wrong. Here's why I don't agree with it, or here's why they weren't wrong, or here's some other information that you don't have. So you need to respond to it. If you don't say anything, if you just say that's wrong, not good enough. You have to provide some more context and more information. Ultimately, there's no legal obligation to provide evaluation. If they provide a bad one, that may be a sign that they're trying to let you go for cause at some point. So the best thing to do is to respond in writing, by the way, not verbally. Verbally means nothing. Send an email. How many times have you heard me say that during this session? Just send an email telling them why you don't agree with it, etc. By doing that, you're protecting yourself. Very important to do. So hopefully that makes sense, PG. For PG, for anyone, if you want to connect with me now that we're ending this session, again, easy to do, very easy to do. You can do that now. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. This is the time that we have for today. I want to thank you all, guys, so much for the questions today, for joining me, for listening. Some fantastic questions. I hope you learned a bit about employment law and your workplace rights, these rights that you all have. Now, I'm going to turn off my camera right now and maybe undo my tie, and I'm getting back to work. So if you want to connect with me today, tomorrow, whenever you need me, just go to employmentlawyer.ca. We can continue the conversation there. I'll be back next week. Don't wait till then if you need me. All right. Thank you so much for joining us. I'm Lior Samfiru, the employment lawyer. We'll talk to you soon. Bye now.